Well, what means does the American constitutional system provide for managing the tensions you just mentioned between principles and values? What do we do when they conflict?
Well, we look to the political and legal system, and we have to be comfortable that this conflict will not necessarily be resolved with any particular magic formula in any one time and place. This is an ongoing dialogue between fundamental principles, and the dialogue itself is part of our constitutional fabric. In other words, our Constitution was constructed not just to provide certain answers, but to provide certain means for answering long-term questions. So our constitutional system allows us to have an arena to have these conversations. For example, in Congress, we can have arguments about the Patriot Act, about the collection of private data. We have presidential candidates who will have different positions, and they have a certain executive discretion through the executive bureaucracy to implement the law in different ways. So again, we can have these conversations in Congress that creates new law, but then there's executive discretion about how to put those laws into practice. Then, of course, we have the court and the power of judicial review. And this is sometimes where these fundamental tensions come to a head. The Supreme Court is not always the final word, but it is uniquely situated to be attentive to minority and small group concerns. The structure of the court is very different from the elected branches. The Congress and the presidency are both designed to be sensitive to majorities, first and foremost. The court is not designed to be directly sensitive to majorities. While it is true that each member of the court is him or herself reflective of a certain majority, meaning the president and the Senate at the time of appointment and nomination as well as confirmation, together the court is not necessarily reflective of any one majority sentiment. Secondly, the court has a lifetime tenure or a tenure under good behavior, which means that they're not only somewhat insulated from majorities on the front end of their decisions based on their diversity of when they were appointed, but also on the back end, that they can make slightly unpopular decisions that may not favor the majority, and they will not be personally harmed. The downside, as we said earlier from the court, is that it does not have enforcement mechanisms. So even though the court on paper seems to be isolated from the majority, it does have an obligation to be heard, and that obligation to be heard will fall back into majority institutions.
Professor Ferrier, that brings us to the end of Lesson 39 and also to the end of Unit 6. So let me thank you so much for being here and for giving us this really interesting discussion. Thank you.
You're welcome. Thank you for having me.
I want to thank our guest, Professor Jasmine Ferrier, for this wonderful, insightful, and engaging discussion on Unit 6 of the We the People text. I hope you have found it and the discussion of the other 5 units useful. If you want to learn more about the We the People program or the other activities of the Center for Civic Education, please visit our website at civiced.org. Thank you.